Gambia we tamala the fi amma mut fanan sama mam dana mo wanan jamareka war Nya papolo don dana can dunya mona dara Reo me sunyu reula nyepa and the joke Nunglenyan Jama sasa sunyu reu Sapante te japante Moy sunyu waref Burialenyo Gelenyan Nasama sunyu digante Nyepa mangu te dono ben lolu La fe mami bayi bon Nyepa mangu te dono ben Jamu Gambia
Jotali makas bilel tanghal masindal biwai Bonyi be nga nuyul masa papa wai Oyal ma aji wako mata nena awane Ñu magal tobaski ji wai Genaaw elek Noël su passé ba ñu tek ci ñaari semaine sang marila tam Lolu lañ fi xam benn baat lolu lañu am juróom ñaari nit ci benn bool lolu lañu xam arjodo ga tambi nang nuyul masa papa ankira jam bul ma jam jama lañ fi am amut xeete amut diine lolu lañ fi bàyyi woon dama ne lolu lañ fi bàyyi woon
I am you, you are me. We are they, and they are we. We are Gambia. I am you, you are me. We are they, and we. We are Gambia. Let us share love and care for each other. We are one, nothing to despise. Let's put a smile on each other's face to keep us strong. If you lead us well. Cause if you fail, we fail too. If you teach me right. Cause if I fail, you fail too. Pick the one from the ground. Together we can build Gambia. For the Gambia, our homeland. We strive and walk and pray day. Time of belief, unity and peace today. So is it in our time? Let's be
Good evening, everyone. I hope you all are having a brilliant evening. Um, I know we are still in a very sad state of affairs, most especially with regards the 69 official numbers of babies, toddlers who have lost their lives due to the acute kidney injury, um, you know, issue in the Gambia with regards to um, medication that um, came from India. Apparently, these medications in the form of cough syrup were contaminated and have chemical components that could be found in air conditions, radiators in cars, etc. Um, but notwithstanding, tomorrow is a very important day. If you have been following me on social media, you would know that I have been very much bringing in and discussing the issue of the Bob Keita trial. And we are at a very pivotal part of this trial. And therefore, I thought it fit um, and prudent to actually come and give a talk about where we are with regard to the trial, dispel also some of the conspiracy theories that are being bandied around, especially on social media, with regards the results of the DNA testing, which we all know the courts have ruled that they would be read, they would be opened. It's a part. It is sealed. We know, as a matter of fact, based on the statements from the state law office and also from the court, that this is a sealed document that would be basically would be open tomorrow in open court, and the results would be known at that point. However, we are also aware that there has been allegations on social media that very senior government officials are actually claiming to know the results of this particular DNA testing. And so we will start with that. We will talk about that, or probably at the either the tail end, or I will get to that. But substantively, we're going to look at where we are at this trial. What are the possibilities? What are the avenues that we have left? And what are the possible outcome of tomorrow's sitting after the results would have been read? Now, I'm going to ask a favor. If every single person that is watching this live video, every single person that's on watching this live video, all I'm asking you to do for me is to just share the video that you're watching. The reason why, because I had explained prior that I'm doing my Facebook Live on this page. I have a very large following on my personal Facebook page, but because the page was restricted, I think the restriction has been lifted yesterday or today. But because it was restricted, I've decided to just use this page and carry on to talk about, issues, social issues, legal analysis and things I do on this particular page, and try to keep my regular personal page as that personal page for, other things. So issues, discussions about Gambia or other things would be done on this page. But because people don't have the notification, so usually people would have a notification on my personal page that I want live and they can follow. But usually this doesn't happen with the page because most people don't know about the page. So all I'm going to ask you to do is that if you're watching this page, just a little favor, just share the page so that it could be widely seen and people can participate and people can be part of what we're doing. And thank you very much. Now, where are we? So we all know that at the final end, when we all know that Bob Keita was charged, he was accused of rape. He was finally charged, an indictment was filed. The matter was in court. We know that at some point he was granted bail by the same court that he's appearing before, and then the state, of course, appealed against that bail on the premise that the offense is a non-bailable offense in the Gambia, and the Court of Appeal upheld the appeal of the state law office, the Ministry of Justice, and his bail was revoked, and he was again sent to remand. So one thing I want to point out, which is quite ironical, is the fact that I think a lot of people forgot that part that he was once granted bail by the same presiding judge, the same judge, Justice S.M. Jallo, who I know is not the favorite of Gambians at this point. But at a particular point during this trial, he ruled and in favor of the defense in granting Bob bail. And when he did this, he was also very much unpopular, especially with the feminist camp and people who thought that ordinarily bail shouldn't have been granted. Now, I have always said, and my position has always been clear, that every offense should be treated on the merits and circumstances of that particular crime, of that particular allegation, and I firmly believe that bail should not be used as a punishment for any person who has committed a crime, as long as our criminal law is based on the principle of presumption of innocence. Because if you're using bail as a means of punishing somebody for a crime that they are alleged of, that has not yet been proven before a court of law, that the individuals have not been found guilty of the offense, therefore keeping that individual in remand until the determination of that suit would amount to punishment to that person by virtue of the allegation that has been made against that person, regardless if the person is guilty or innocent, regardless if the courts would find him innocent or guilty, regardless of the evidence that would be adduced in court. So therefore, I have always believed that if you go and do a historical dive and look at the aspect of bail, you would understand that bail was never meant as a means of persecution or as a means of punishment. Bail evolved, and it was done on the basis of actually protecting the victim and or protecting the accused person, in the fact that it was guided on the substantive reasoning of having the person who has been accused to be present in court and to defend himself and or to be available to the court in order for the trial to take place. So these are the real historical basis for bail, and it was never meant to be a form of punishment before the determination of a suit. So I firmly believe that even though the courts have ruled that this is the position, but we have seen again where people who have been accused of similar offenses, of the same sort of offense, of the same crime that Bob has been accused of, have been granted bail by the very same courts, which I believe is right, because every adjudicator, every judge would look at a case by and view that case and weigh the merits of that case based on the circumstances and uniqueness of that case. And therefore, there is no case, there's nothing in law that has a blanket application. I mean, everything would have to be looked at by its own merits. And of course, precedents are there to guide where the facts and or legal issues seem similar. You would then hope that similar issues, similar facts, and similar circumstances will be adjudicated in a similar way, especially where a higher court has already adjudicated on such matters. However, substantively, every case should be looked at and weighed based on the uniqueness and circumstances of that peculiar case, and not give it a blanket interpretation in the sense that no matter how frivolous the charges, no matter how the lack of evidence thereof are there, you would deny a person, you would keep a person in remand close to 2 years, a matter that has been prolonged for 3 years. And in the event that person is not found guilty, we know, as a matter of fact, as stated and or reiterated by the Minister of Justice and Attorney General when he appeared before the National Assembly, that there are no provision where victims or alleged victims who have been found innocent by the courts and basically wanting to seek redress and or have some sort of compensation from the state law office. It is not provided for. And therefore, this is one of the reasons or one of the things they're looking when, with regards to the overall revamp of the justice delivery system in the Gambia. So therefore, what this really means in simple language is that if you have been held, for example, a person like Bob being held for 2 years, comes out, he's found not guilty, he's found to be innocent, there's nothing that he stands to gain with regards to compensation of any sort, because there's absolutely no provision for it, as stated by the Minister of Justice. Now, that said, so of course he was granted bail by the same Justice SM Jallow. So, and that is why I have always said that for me, I cannot as a lawyer, as a member of the Gambian bar, I mean, as a person who understands the regard, the dignity, and the respect that is expected of every person, of every individual, with regards to members of the bench, members of the bar. I cannot use derogatory remarks against the person of the presiding judge, Justice SM Jallow. I am not at liberty to do that. I have seen other people do that. I choose not to take part in that. However, for me to raise issues of concerns on certain things that he has done, certain things that he has said, for me to come back and look and analyze his rulings, that is something I'm at liberty to do as a Gambian citizen, exercising my freedom of speech, exercising my freedom to talk on issues and to give legal analysis on what I understand. However, I'm not saying I know it all. I don't. I'm learning. I learn from people. I ask questions. I research. So therefore, I can poke holes. I can critique. I can look at what he has said, what he has ruled. I can do a deep dive and analyze it. But it will never ever be reduced to insults or derogatory remarks against the person of the presiding judge, because I am not that way inclined, so I can't do that. But when I try to analyze and look at this situation, you could tell that the same judge that people in the Bob Keita camp hate and loathe so much is the same judge that was frowned upon by people on the other side when Bob Keita was granted bail. So we should always remember this, that in life, and I believe it's a learning example, it's a learning curve, that in life you would always expect the unexpected. So based on circumstances we don't know, as it seems to appear to the public and to everyone, is that the judge has taken a position whereby he's being very hard on Bob. This is what I mean. Really, it seems like from the outside, listening in to the proceedings of this case. However, I am not at liberty to say anything or make calculative decisions or pronouncement as to the biasness of the judge. However, I have raised objections. I have critiqued his rulings, his orders, and the manner by which he has gone about to do certain things. And these were logical, reasoning behind these critiques. So I leave it at that, and we'll see how everything eventually plays out. Now, so at the tail end, the prosecution proved the prosecution presented its case in court, and at the very tail end of the prosecution's case, when they had actually called all their witnesses, we saw that an application was made to the court for DNA testing to determine the paternity of the alleged child that was born out of the alleged act that happened against the alleged victim. I'm using very diligently, I'm using the word alleged to describe all these things, because as far as I am concerned, as far as my knowledge base will take me, the victim is an alleged victim until it is determined by a court of law that indeed he is a victim, and indeed the offense that was alleged against the alleged perpetrator has been upheld by the court, has been proven, and the court have satisfied itself that indeed, yes, this is the crime that occurred, that was against her person, and therefore she becomes a victim. So until that happens, she is an alleged victim. The perpetrator is an alleged perpetrator. It's not been proven in court that, yes, he's guilty. He's not been found guilty by a court of competent jurisdiction. So he is an alleged victim. The crime that occurred is an alleged crime. It has not been determined by the court that it occurred. So I'm using these words very, very, very wisely and carefully. So basically where we are is that DNA testing was conducted. And we know that the results were sent to Ghana. And we also know that the defense have absolutely objected to the DNA testing. They wanted no part of it, wanted to be, they did not want to be associated with it at any cost. We saw the missives that came from the Ministry of Justice to the defense, from the defense back to the Ministry of Justice and back again, and each side holding to their position. One side, of course, advocating passionately for DNA testing, whilst the other side passionately is defending their rights not to participate in the DNA testing, for the simple fact that they believe that they have been shortchanged with regards to how the DNA testing was conducted, or how the not DNA testing, but how the blood samples, how the biological samples for the DNA, for the eventual DNA testings were obtained. They believe they were not part of the process. They believe that in a matter of such that was before the courts, they should have been informed, and there should have been active participation from both the defense and the state, and of course I would have expected that the courts would as the adjudicator in this matter, would ensure that an independent body is present to give credibility to the whole process. And this is what the defense, and that's the foundation of the rejection of the whole entire process of the defense with regards to whatever it is that was going on. Now, notwithstanding, the order of the court was that DNA testing should be done and that blood samples should be taken, and we saw that this was done. Another reason why there has been a public outcry, or should I say there has been doubts raised, was with regards the joining of the alleged boyfriend of the alleged victim, who was never a party to the suit, was used, I think, I'm not even sure if he testified. I think so. I'm not too sure. I'm so confused with this case now, whether he testified or not, but he was never a party to the suit. However, we saw that the application that was made to the courts was for DNA testing to be conducted on the person of the alleged perpetrator, the alleged accused person. But eventually we saw that the order was for both the accused person and the boyfriend to be taken to the RVTH so that they can conduct a DNA testing. Now, they could collect the blood samples. Now, I ordinarily don't understand, and I've said this before, and a lot of people have said this, that I don't understand the rationale for having the boyfriend, because the boyfriend is not standing trial. The boyfriend has not been charged. I mean, he's not part, and this is not a civil matter, so this is a criminal matter. So the boyfriend has not been charged. The boyfriend is not part of the trial. The boyfriend is not a party to the suit. How the boyfriend can be compelled under such circumstances to avail himself to blood, to giving his blood or other biological samples in order to do a DNA test to determine the paternity of the child. I don't know what it's the foundational basis in law for this. I do not know, but of course the courts are well respected, and the order of the courts had to be respected. I believe if the boyfriend had the opportunity to have a very sound legal advice, I believe he could have objected to his inclusion in this testing, because I believe it amounts to a breach of his fundamental human rights. I mean, you can't force a person or order a person to just, I mean, yes, the courts have powers, judges have powers, but that does not mean that judges are not guided by rules and regulations. They're not guided by the law. So that is something that we do not understand now, but hopefully, I believe when this matter is all over and the judge is giving out his judgment, I believe he would have to factor, the reason and the rationale for including the boyfriend in this whole process. But this has further dented the thought process and or doubts that people already had, individuals, public members of the public had, with regards to the way and manner that this case has been conducted from the very start, from the inception of everything. So there are theories out there that the reason why the boyfriend had to come in, or the reason why the judge would include the boyfriend, was to legitimize a further conspiracy which says that the blood samples of Bob would be switched with that of the boyfriend in order to determine, or in order to occasion, a final outcome where the paternity results would be positive. Now, Remember, is this a possibility? I I don't know. I don't know. Like I said, I can't make rash and very negligent statements. So I can't say that is the reason why the courts would do that, because I don't know why would the courts want to at all cost. I mean, I know as a prosecutor, once an indictment is filed, the prosecutor at all cost wants to secure a conviction. We all know this. Generally, this is what happens all over the world, in England, in America, in Western, anywhere. Whilst a prosecutor will diligently prosecute. And that is why before a prosecutor decides or before the state law officers decide to file an indictment or get a person or bring charges against a person, they would have established the weight of the evidences that they have before them. And therefore, when they march to court to file that indictment, they believe in their hearts and minds that this is something that they can secure, that a conviction can be secured with whatever evidences they have in hand. So absolutely, without a shadow of doubt, I believe that the state law office, the prosecutors in this matter, are going to do everything at all costs to ensure that a conviction is secured. Because like we all know, lawyers have objectives and goals like every other profession. When a good doctor works into that theater, that doctor wants to ensure that the surgery he or she performs eventually is successful and the patient lives and survives and is healed from whatever ailment they had at the time. When an architect goes down and sits and wants to draw a building, they draw a building not only in the abstract, but they draw buildings, get into the tangible aspect of architectural drawing to eventually realize and see these drawings that are on paper come to life by through the erection of buildings or other things that they have put on paper and have drawn. So this is their eventual. Like when a builder goes to work, he goes to work and lays a proper foundation that would eventually erect a proper structure that he can sit back, admire. He doesn't want to erect a structure that would crumble in a minute or two. No, that is not the outcome. When a farmer goes out to sow seed, he does it in such a diligent way in order that those seeds would germinate, they would fertilize, and a crop is soon a crop begins to sprout out, and that they would reap the fruits of their labor. So just as in every profession, when a state prosecutor goes to court with an indictment, the absolute belief and conviction is to do whatever it takes to secure a conviction. So that is certain. However, I do not see the rationale. I don't understand the reasoning whereby a court would go beyond all means and want to secure a conviction where the court is just an adjudicator, and all the court should do is to adjudicate on this matter fairly, in an equitable way, in a just way, so that justice is served, so that whoever is alleged of this offense and that the evidences are such that it can prove that, yes, the crime has occurred, that person will be found guilty. But where the evidences do not lead to the legal conclusion that, yes, this person can be found guilty, that person would be found innocent, and that person would be left alone to go about and carry their business. So therefore, I cannot understand the theory, the conspiracy theory that is there, that is being bandied about, that the order of the court was done by inclusion of the boyfriend of the alleged victim in order that the blood samples would be switched and in order to orchestrate a final outcome of the DNA test results. But like I've said before, it is still mind-boggling to both lawyers and non-lawyers as to why the boyfriend was included in this testing. And it begs the question. So if the test results comes out and indeed it states that the boyfriend is the father of the child, what would happen then? Because as far as my knowledge base is concerned, the boyfriend is not a party to the suit. The court cannot now find him guilty because there's not been any charges preferred against him. The court cannot now grab him and take him to remand. No, the state would have to file an indictment. They would have to charge him based on the evidences that they have, and it would have to be determined by another court of competent jurisdiction. So I do not see, but let's wait and see how that plays out. So that brings me to the point but before I get to tomorrow's testing, I want to talk about the whole theory that's out there with regards to the results being known and by certain individuals. First and foremost, Ghana is a very, very highly recognized society where integrity and credibility with most things are of a particular standard. This cannot be faulted. We all know this. And as we have been informed in court, the testing results were sealed. And from the testimony of Mr. Jatta, PW9, which is the 8th or 9th prosecution witness, he gave testimony and reiterated the position of the State Council that the test results were sealed and have not been opened. Neither the police nor the Ministry of Justice nor the defense nor the state prosecutors are aware of what is inside that result. So I personally believe that what is happening is nothing short of gaslighting the public, causing the public to be concerned for something that they should ordinarily not be concerned about, making people to be agitated for something that ordinarily they should not be agitated about. Now, it is so remote. I mean, I know Sidinjai is the deputy speaker, but it is so remote for Sidinjai as deputy speaker to have knowledge of a DNA test results that is supervised and guided by a court of law, where even the Attorney General or the Solicitor General or the state prosecutors that are actually prosecuting this case do not know the contents of that result. So therefore, in all accounts, whether this was said by Honorable Sidinjai or it was not said and it was something that somebody made up, the conclusion that I can come to is that it is false. It is absolute false. The Honorable Sidinjai, as Deputy Speaker, would have knowledge of a result that, I mean, let's look at it the other way. The state could have come to court. And I said this when I did my legal analysis the last time, that even though Justice S.M. Jallo had said that the order or the DNA results was the court's, and that he gave that order and therefore it belonged to the court, I have absolutely objected to this because that is not factual. The DNA testing result does not belong to the court. It has not been tendered in court. Evidence has not led to that. It has not passed the admissibility test in court yet, and therefore it is not a property of the court. It is a property of the prosecution at this point. And therefore, it would have been more prudent. The only entity, the only individuals that would have vested interest in knowing the contents of the DNA test results more than any other person would be the state law office. Therefore, if somebody had said that, oh, the Solicitor General said he knows what is the result, I would have remotely, in a very remote manner, in a very, subdued manner, I would have believed. If somebody had said that the Attorney General and Minister of Justice has mentioned somewhere in a gathering or had confided in somebody that he knows what is in that result, I would buy it. But the Deputy Speaker's office is so far-fetched from the Ministry of Justice that I do not know why and what reason and what would occasion such that the content of such results, which is highly contentious in a matter that has taken worldwide attention. Public scrutiny on this case, on this trial, is at an ultimate high. Why would those results be divulged to a deputy speaker? What would be the rationale? So it does not make sense to me. And for me, it defies logic. Whoever had said this maybe said it out of wanting to bluff, wanting to brag. But I do not also believe that it makes sense. It defies logic that the state law office would go through the pains of securing the attendance of a forensic expert all the way from Ghana, fly him to Gambia, get him to come to court, get him to lead evidence, get him to talk as an expert witness for a result that is already known to all and sundry, including the deputy speaker. I don't believe that. And I just believe, as is very, in Gambia, it is very common. Everybody knows that everybody is on edge. Everyone wants to know the outcome of tomorrow's proceedings. Everybody is watching. Gambians in the Gambia, Gambians outside the Gambia, non-Gambians, the state, other sectors of society, civil organizations, international bodies in the Gambia. Everybody is watching. This is a it's a case that has got unprecedented attention. Unprecedented attention. I have never, with my little knowledge, been aware of any matter, any case that has caused such widespread interest where the matter was not politically motivated. So therefore, I believe that a lot of errors have been made by the state prosecutors and by the state in prosecuting this matter. And I believe that even the state would acknowledge these errors. Even the state would acknowledge these shortcomings. That I do not believe, under no circumstances, at this final point, when the brand of the Ministry of Justice is being tested, where the name of the Ministry of Justice, the good name of the Justice Ministry, is on the balance, is on the line, where the Justice Ministry is being looked at a situation where it can either break them or make them. They can either lose their credibility for a very long time, or they can make it, they can build their credibility. Would the Ministry of Justice allow, would the Justice Minister allow for everything that has happened and that has surrounded this case, allow for the test results to be told to a Deputy Speaker of the National Assembly? Of what value? So when people make statements, no matter how grand, let us look at the logic. Let us look at the circumstances behind it. What would be the motive? What would be the motive? So I personally do not believe, I absolutely, beyond a shadow of doubt, do not believe that there is any individual, any person who is aware of what is in that result, not even the person that secured the transportation of the samples to Ghana and back. The only person that I know, the only person or group of persons would be the forensic expert that is coming to testify because he conducted the testing. He knows the results. Of course, the results were sealed, but I'm sure he knows exactly. So he is the only person, and probably the individuals that he worked with in Ghana, who can accurately state, the results of that testing. Now, there's something that I wanted to say, and again, I like to go over things. So when people say something to me, I take it and then I process it. And when I process it, I then decide to take out what doesn't make sense, what defies logic, and then begin to play with it. Now, the state, as I've mentioned, really owns the DNA testing. That's their property. They ask for DNA testing until they tender that it is their evidence. It is not the evidence of Bob. It is not the evidence of the defense. It is the evidence of the state. So I don't know if people are thinking. Therefore, if the state wanted to open that test result, they would have done so and they would not have violated any law known to man in the Gambia. If that result came and it was sent to the ministry, remember, the forensic expert is a client of the Ministry of Justice. It's not a client of the court. The court is not even aware. If you understand management and if you understand administration, the court is not aware of how the forensic expert was paid. The court is not aware on the financial management, the financial things that occasion that testing. The courts did not facilitate the movement of an official of the police to Ghana and back to Gambia. The courts did not facilitate that because that is not the evidence of the court. And that is why I have said that Justice Jallo saying that the test results is the court, is wrong, because it is not. Justice Jallo has no legal power, no legal authority, no legal right over that test result. The Attorney General could have given instruction for the test results to be opened. In fact, when we went to court, we saw that the defense raised an objection that they should have been served with the DNA testing and the DNA results before they come to court. They should have been put on notice. And we saw that the state prosecutors did not object to that. In fact, the state prosecutors agreed with the defense and wanted to open the results there and then. It was the courts that ruled that it should not be opened. It was the courts that ruled that it shouldn't be opened. And therefore, I want people to understand that this DNA results is the property of the Ministry of Justice, of the state prosecutors. They can open it. They can read it. They can decide to tear it apart and say, you know what, we are not tendering this as evidence anymore. Will the courts force them and say, by and force, come and tender that evidence? It is the evidence. And what the court can do is to weigh the evidence before them. If the courts feel that it was detrimental to the state not to tender the evidence of DNA and it would rubbish their case against Bob, so be it. What the courts would look at is the evidence before it. The courts would never go on a fishing expedition to get evidence. And that's why it is still disturbing for me that the judge would say that he gave the order and therefore the test results belongs to the court. That was wrong. Yes, he gave the order and the order was only legitimizing the application, the process of the state law office, because the application for DNA testing was done on the occasion, on the instance of the Ministry of Justice, of the state prosecutors. That application was done at their instant. That is their property. That is their show. It is not that of the court, neither is it that of the defense. In fact, we know it is not the defense because the defense mob, they came out clear and say, we're not part of it. We don't want to be part of it. So therefore, this whole business of, oh, no, that, no. There is nothing factually, legally wrong if the state prosecutor or the Solicitor General or the Minister of Justice decided to give their blessing and say, you know what, open the report and let us know what is in the report. What would it do? Would it change the authenticity of the report? No, you can open the report, still get the expert witness to come and lay evidence and put in that result into evidence and allow it to go through the admissibility test. And of course, the defense can object. And finally, the judge can adjudicate whether he feels that the evidence has been properly laid, the foundation has been properly set, and that the evidence is admissible, and therefore the judge would rule regardless of the objection of the defense and regardless of what the state prosecutors have done. The presiding judge will weigh the evidence, and then he can admit the test results in evidence. When he has admitted the test results in evidence, it then becomes the property of the court, because the evidences that have been admitted before the courts will eventually allow the presiding judge to come to a decision and conclusion on this matter. I hope I have adequately explained that. Now, let's hit the topic. Positive or negative? What follows? Positive or negative? What follows? First and foremost, let me establish something. I know I have said this on numerous occasions, but I'm just going to say this one more time. There has been a lot of questions initially as to why the importance of DNA testing in a case of rape. I'm going to take no, let me address this issue and then I'll address this question. Okay? Now, ordinarily, paternity cannot in any way decide rape. Paternity cannot be the determinant factor of proving rape. No. That's generally. That's ordinarily. Now, however, where two things are at play, two things. One is where the alleged victim is a minor. And therefore, because the alleged victim is a minor, and under Gambian law, as it stands, a minor cannot have consensual sex. A minor cannot have consensual sexual intercourse. The reason why the minor cannot have consensual sexual intercourse, and when I say consensual, I mean agreeing to having sex, is because the law has defined it that that particular minor does not have the legal right to determine and or give consent. That is the law. So whether that minor got up from her house, went to the alleged perpetrator, decided in a very nice way, even wrote a contract, a written contract, and say, I, Mariama Jones, 15 years of age, I am agreeing, I am happy, I am absolutely in agreement to having sex with Mr. James Tunkara, who is 21 years old or 30 years old, as long as that person is an adult. The law says that person does not have capacity to give consent of any sort. This is the law. We all know that, we are aware. In fact, I feel that the law maybe should be changed, because we all know that now that 17-year-olds, 16-year-olds are highly sexually active. So maybe that law should be changed. I think in England it has been changed to 16, and I think in America the same. I think other countries are changing it. Some countries are now even bringing it down to 14, but that's a legal subject discussion for another day. But what stands is that under Gambian law, that person cannot give capacity. So we're not saying, the law is not saying that, oh, they didn't agree. So I would see people say that, but we know she was having that, we know she did it, we know she's been doing it. No. The law is not concerned about what she has been doing. The law is just clear. The law says whether she's been doing it, whether she's not been doing it, it is not law. It is not legal. She does not have the capacity. Now, I believe there should be adequate sensitization on this law, because I believe, based on a cultural history, I don't think people understand this, because we know people marry 16-year-olds. We know some of our parents in the cultural context got married when they were 16, some when they were 15. So it's very difficult to understand this law. So I believe adequate sensitization should be done on that. Now, the second part is where the alleged victim has given sworn testimony to say that as a result of the alleged offense of rape, she became pregnant. Now, you see the interlink. You see the interlink. Now, if an adult, I'm going to play with this a bit. Now, if an adult was taking the place, or let's say Bob was being charged for raping an alleged adult who became pregnant as a result of that rape, paternity test would not have determined that rape had occurred. Because that person is an adult, therefore there's a possibility that person can agree to consensual sex. What it means is that the prosecutors would have to prove a case of rape to show that there was no consent, to show that there was a lack of consent from the adult who became pregnant. That would have to be the evidence that would have to be led by the state prosecutor to be proven in court. That this adult that is saying that Bob raped her, it was not consensual. So it would become the word of Bob against the word of the victim, and therefore they would look at the evidences to show whether there was consent or the lack of consent thereof. Now, but because this person is a minor, and we have already established that the law has already stated that this minor cannot give consent, therefore, it would be stupid of the state to now begin to look at consent. They would never look at consent in the evidences, because the law does not provide for that minor to give consent. So where that minor had accepted, yes, the minor accepted, the minor said, yes, I want to have sex with you. But the issue of consent would not arise, because the minor does not have the capacity, does not have the capabilities, does not have the legal standing to give consent. So therefore, you now see why in the case of Bob Keita and the state, because the victim is a minor, and because the victim has alleged that the rape is a consequence of that action, it therefore becomes important, because whoever is the father of that child has committed an offense of statutory rape, because the child does not have the capacity to give consent. So whoever, whether it is Alpha, Modu, Pate, Jalo, Makumba, Jere, whoever is the father of that child is guilty of statutory rape, and therefore a prima facie evidence has already been established against that person based on the paternity test. So in this case, because the alleged victim is a minor, and because the victim is saying that she became pregnant because of that sex that she had or that rape, then the issue of paternity is very crucial. And as a footnote, one thing I will say, and one thing I have always said, and I'm sure people in the state law office would not like me for saying this, but I know also in their hearts and minds, they know that what I'm saying is the truth, is that the issue of paternity in this situation must have been the basis of a criminal charge against Bob Keita. The DNA testing, the paternity result, should have been the basis, the foundational basis before any indictment is filed against Bob Keita. I would say this to the Attorney General if I were to meet him any day in the street and met him. I would say it, and I will not blink or bat an eyelid. I would say this to the state prosecutors. I would say this to the investigators that were part of this whole process, and I would say it to any Gambian legally minded person. I will say it with all authority, with all conviction, that the basis, the foundation of a charge against Bob, what should have made the preliminary investigations of this matter should have been a determinant factor. Nothing else should have been, and more than the paternity results of that child. Because where it was found that yes, indeed, the paternity results was positive and Bob was the father, they had a beautiful case to present in court, because therefore they don't even need to prove the higher offense of rape, because statutory rape has already occurred. It was just to put an icing. That was the cake. What they would need to do is put an icing on the cake. And where it was determined that Bob is not the father. I'm sorry, guys. I'm having a lot of background noise because I'm somewhere and there's a crying. So I'll just mute my call for a minute, and then as I was saying, and where it was determined that the result of the paternity was negative and Bob was not the father and somebody else was the father, then it was clear cut. Because what it would mean is that the testimony of the alleged victim was not honest and truthful, because it would have determined that the alleged victim, claiming that she was raped by Bob, and then the paternity test shows that there was somebody else who's the father, and she had already alleged that by her statement that the only person she has slept with is Bob, and that as a result she got pregnant. If it showed that somebody else got pregnant and got her pregnant and it was not Bob, that would have given the state prosecutors, it would have given the police or the individuals conducting the investigations the foundational basis to streamline their charge and know that we are dealing with an alleged victim who is neither truthful or honest to the prosecution or to the police or to the people that are conducting the criminal investigation. So I'm confused because I don't know if my technical guy, I'm seeing two different pictures on the phone. So I don't know if you can still hear me, because I wasn't even looking. So I'm going to just mute my call and speak to my technical guy to know whether I'm still on or not.
Gambia we tamala Nafi amma mutfanan Sama mamda na mawanan Jamareka war Nyapa polo don bena Kandunya muna dara Reu me sunyu reula Nyapa anda jog Nunglenyan Jama sasa sunyu reu Sapante te tapante Moy sunyu waref Burialenyo gelenyan Nasama sunyu digante Nyapa mangu te dono ben lolu Lafi mami bayu bon Nyapa mangu te dono ben Gijamu Gambia
Jotali makas bilel tanghal masindal biway Bonyi be nga nuyul masa papa way Oyal ma aji wako mata nena awane Ñu magal tobas kiji way Genaaw elek Noël su passé ba ñu tek si ñaari semaine sang mari la tam Lolu lañ fi xam benn baat lolu lañu am juróom ñaari nit ci benn bool lolu lañu xam arjodo ga tambi nang nuyul masa papa ankira jam bul ma jam jama lañ fi am amut xeete amut diine lolu lañ fi bàyyi woon dama ne lolu lañ fi bàyyi woon
Okay. Sorry about that. Of course, I'm not at home, so I had a bit of a background noise. So I'll just continue from where I stopped. So basically, what I was trying to do was to establish the reason and importance of a DNA test in this matter, and also to demonstrate the rationale for my statement of saying that the DNA testing should have been one of the should have been the basis of this whole trial. Honestly, it should not have been done at the tail end. Rather, it should have been what would have really occasioned such a trial. Now, what would happen? What would happen if tomorrow we go to court and it is determined that Bob Keita is the father of the said baby? What happens? What happens if we go to court and they read the test results, the seal is broken, and the result says that Bob Keita is the father. Now, what I believe would happen is that the prosecution would tender that evidence. I also believe, based on the pronouncements of the presiding judge, that this particular evidence would be admitted by the court. I also believe that the defense will object to the admission of this evidence on the basis that the evidence is not credible as far as the defense is concerned, and that the defense were not a party to the collection of DNA samples, and the defense would object on the basis that they have filed an appeal at the Court of Appeal and have also filed for a stay of execution of that particular order that occasioned the collection of blood samples and the eventual DNA testing. So this is what I believe will happen. And also, after all of this have taken place, I also believe that the presiding judge will make a ruling, and he will overrule the objection of the defense, and that the evidence will be admitted. And I believe there and then the state would close its case. When I say close its case, I don't mean that they will stop prosecuting Bob. No, I mean they will rest their case. That will be the end of the prosecution's case. For them, it would be like they've done everything and they've just, like I said before, they've done the cake, they've baked the cake, everything is on. It came out nicely from the oven, and they will just finish it up with the icing. They will have nothing more to say. They would have done everything that they feel they can possibly done in this matter. They will rest their case and allow the defense to now enter and start their defense before the court. And I also know that if it turns out, so now I'm giving the scenario where it turns out that the results are positive. And what will happen there and then, I also know that the defense will not be tired, and the defense will submit a no case to answer submission to the court. The defense will say that the prosecution has not proven the offense of rape. And therefore, the defense would say that their clients have nothing to answer, because remember, the defense is not giving legitimacy. They're not legitimizing that whole business of this DNA sample. They are hoping and believing that they will succeed in their appeal at the Court of Appeal, and that DNA testing, DNA sample will be dispensed with, would be set aside, would be struck off. This is what they are hoping. This is what they are believing. And therefore, based on everybody that has watched the case, watched this man, will all agree. I mean, this is not prejudicial to the trial at all in any way, but we will all agree that in the absence of the DNA testing, the prosecution has not proven a case beyond reasonable doubt. They have not managed in the presentation of their case to reach that threshold of beyond reasonable doubt to prove a case absolutely beyond Bob Keita with regards to rape. They have not. And therefore, where the Court of Appeal, or where, by a stroke of luck, can rule that that DNA testing should be set aside, and it shouldn't be part of the evidences that the courts will eventually look at to give a final judgment or ruling on this case, on the guilt and or innocence of Bob Keita, then it would mean that the state, in my opinion, and in the which is the opinion of so many people that are following this case, is that the prosecution has not proven their case against Bob Keita. So this would be the outcome. And for me, it will be a whole process, because this is now when Bob's defense is starting. Everything that was happening, all the objections from the defense team, from the lawyers of Bob Keita, these were all objections. These were all objections. and it is now that proper the defense of Bob is beginning to start. So we're going to see another prolonged, I mean, except if things are going to radically change and circumstances are going to change, and that we will see a speedy trial like we're seeing in the Sainabu Mbai and others manslaughter trial. Then of course we could expect a very quick outcome of the case. But where the slow pace of the case, as it had been from time immemorial, is what we're going to expect, then we would know that this is going to be a very long haul and it's going to be a long process. Now, let's flip. Where it is determined that Bob Keita is not the father of that child, two things would happen. And this is, for me, I'm laughing, I'm smiling, not because I'm smiling at the situation. I'm smiling because I am waiting to see, because this is of interest to me. I mean, if you're a legal person, somebody that follows litigation, I mean, like I do 24/7, I don't sleep at night. I'm just watching courtroom drama and litigation, and just being a lawyer and having seen things and how courtroom theatrics and courtroom drama, plays out. I would want to see the position of the defense, because remember, the defense have refused to give legitimacy to the DNA testing. The defense have said that the DNA testing has no credibility, that they are not part of it. They don't want to be part of it. This is what they have said. They have consistently and constantly objected to anything that has got to do with DNA testing. But if it turns out that DNA testing result is what is going to declare Bob Keita a free man, how will the defense now want to associate themselves with that DNA testing? Is what I want to see. I want to see the brilliance of the defense team. I want to see how LS is going to come up and take a position and identify with something that he has. Absolutely. Remember, he also has a pending appeal to set aside that. So is he going to now say, okay, fine, let me stand my ground and go ahead and now say that I don't want to associate myself with that result, and therefore I'm going to wait until the determination of the Court of Appeal results, or I am going to make another application that a DNA testing is done where all the parties are going to be present. Because remember, by doing all of these things, Bob Keita will have to continue to be in remand, because the case will continue to prolong. And that is where now the state can decide to say they ask for an adjournment because they're busy, they can't come to court, and nothing can come out of it. Nothing can come out of it. The judge might be sick, something might happen, and Bob Keita will continue to languish in jail. So I don't know if you guys are following me. If you're following me, or I'm getting you all confused, just by way of comments, just let me know. But that would be a masterpiece legal maneuver that we're going to see, and I hope LS is now doing an extensive research. I know he's a criminal lawyer of phenomenal repute. However, I don't believe such has ever happened in our criminal history, in our criminal jurisprudence before in the Gambia. So it is going to be absolutely phenomenal tomorrow, because if that happens, I want to know how he can now identify with a process that he has openly bastardized in open court. I mean, he does not want to be part of that process. In fact, if you mention this process, LS gets upset. This is his position. But what happens now, if this process comes out to be the saving grace, the salvation that his client needs? So that's one. The second part is, if the results turns out negative, should LS do something? I don't believe, if I were the defense lawyer, I have nothing to do. I'll shut my mouth, I will sit down, and I will watch the prosecution's next step. What will be the prosecution's next step where the results turn out negative? There is only one step that the prosecution can take, Because if the prosecution want to press and move forward where the DNA test result have showed that Bob Keita is not the father, it will be an issue of probably a riot or something that will happen in the Gambia. It would be that. So obviously, as a prudent, as a wise state law office, I know that absolutely if the DNA test results comes out and it is negative, they would instantly. I don't know how this is going to play out. I don't know how we're going to go about the process. If they're going to have to take a short adjournment, run to the Ministry of Justice, prepare the processes to enter a nulli prosecute. What a nulli prosecute, what it basically means is that the state will discontinue the criminal trial against Bob Keita. They're basically withdrawing the charges or the indictment or whatever it is, or how you put it. But the criminal trial against him would be stopped there and then. So probably they'll take a short adjournment. They will run back to the state law office. They will come back. They will say that, okay, this is it. We're entering a nulli. And of course, there and then Bob will have to be a free man and Bob will have to go. I do not also expect, if that happens, the presiding judge will say, come back tomorrow for a ruling. No, it's not going to happen, because I know tempers are high. I know that people are not going to allow. I know this. Don't ask me how I know, but I know that people will not allow, if that was to happen, people will not allow for Bob Keita to spend one more day in remand. So honestly speaking, I do not also believe that the judge would decide to adjourn for 2-3 days to come and give a ruling. No, I think if the state makes an application to enter a nulli, I think it will be, I know obviously the defense will never object to the state entering a nulli. They would object. LS will be silent. LS will be quiet. LS will have nothing to say. LS does not even have to put up a no case to answer submission at that time, because all he has to do is fold his hands and allow the state to carry on with whatever they're doing. And there and then, I believe the presiding judge will make a ruling and Bob will be a free man. And then we will know what happens next. The state will now have to decide, because it's not by and force that the state is going to charge whoever it is that emerges as the father of that child. They will have to weigh public interest. They will have to see what is the best interest of all the parties involved. They can decide to charge him. They can decide not to charge him. And there's nothing that anybody can do about it, because they have the prerogative to do that. And that's what it is. So these are my analysis, and these are my predictions, my legal predictions of the outcome of tomorrow's case. You guys, of course, we all are going to be glued. I mean, you all know that I follow the proceedings live as it is going. Every word of whoever is talking, I'm listening to it live. So this is what is going to happen tomorrow. Everybody's going to be glued. I've given my predictions. You watch out how it plays out. Of course, we're going to come back tomorrow night. We're going to do a whole analysis on everything. We're going to check and see, what did I say that happened? Was my prediction right and wrong, or was I wrong? Did something radically different happen, and things like that. So it's going to be quite interesting. I have my guest now who is late, so I've been deliberately punishing her and ignoring her, because I've told her she has to be on time, and I'm setting the pace for next time so that she will be on time. I know she's a very busy lady. She's everywhere, a phenomenal person. So I've wrapped up. I'm going to get Nene Frida Gomez to come in, and Nene, I'll allow you to say a few words before. And then what I'll do is I will ask you questions, factual questions, because you're on the ground, and then you can answer. And by way of our discussion going back and forth, the audience can benefit and get a better understanding. I hope you've been listening to me. So first, I would like to hear your responses of what you feel are my analysis, and then you can take it from there. Thank you, Nene.
Okay. Thank you very much, Mel. It is always a pleasure to share a platform with you. You know, I know you too well. I know you were doing that deliberately. I know you very, very well. But guess what? I don't mind, because this is a discussion about somebody I love so much, somebody that's dear to my heart. So I'll be patient and wait for you to punish me as long as you want. I know at the end, I'm going to come on. So you succeeded. Thank you very much. I mean, I've listened to you from the start of the program, and you have been spot on. Again, you've been following keenly, you know, issues that have been happening. You've been asking critical questions. You've been doing follow-ups. Somebody might sit there and think, how does he know everything? Or how is he able to do such a brilliant analysis? Well, I mean, boy, oh boy, Mel will be on your back every blessed day to make sure he gets everything right? So definitely he's been following, and you got it right. You know, I sat there listening to you when you were giving your analysis or prediction. Should the results come positive? I was like, oh boy, that's so difficult to hear. You know, that's so not nice in the hearing. But again, these are the realities, and we have to face it. And one thing Ellis was telling me the past 2 days, you were so relaxed. You were just okay. I said, for some reason, my instincts, I'm following my instincts. Since day one, I have said to myself, I believe my friend, I believe my brother, whatever he told me. But then again, the way the judicial system works is so different from what I want and how I want it done. It's very, very factual and true that there has been so many loopholes. There has been lapses. There has been inconsistencies. And at some point in time, you will think it is the state that is really having a case against Bob instead of they're the prosecutor, state prosecutor. And that is, you know, by virtue of their actions or their interactions of the witnesses and the issues that they need to take care of. But then again, thanks be to God, we are here. Tomorrow is just less than 24 hours away. We believe the results will be open tomorrow. I don't see any reason why it will not be open tomorrow or read out to the public. And my prayer or our prayer is that it will be to our own interest, or it will be negative for Bob. We really don't care about anybody else. Our own interest is to ensure that Bob gets out of prison. And the only thing that can get Bob out of prison easily now is the results, if the results turn out to be negative. That's what he believes. And that's what I believe. That's what so many other people believe. You know, our conversation yesterday was about that. I mean, I was there on Saturday on my birthday, you know, and we had lunch together. It was just like, you know, a buffet and everything. The atmosphere was nice. But before I left after the prison, we had to have like a one-on-one. We had a one-on-one, and that was the questions. He's very, very inquisitive and curious about what's going to happen and here and there. But one thing that really I admire from him, his belief in God, and whatever the results may be, he believes in his stance that he is not the one, and he will take it in good faith, and he is ready to fight on. He is not giving up, which really also always motivates me when I sit and talk to him. And duma de muna chalit, parce que suma gise how strong he is and how gom yala he is. I cannot do anything or break down. So man, I drive my strength and my strongness and everything else from him. So that is what his belief. Today also the conversation was that, you know, and he was like, have you had anything? Is the expert in town? I was like, okay, unfortunately, I haven't had anything, but I want to believe that he will be in town, because there is no reason why he shouldn't be in town unless unforeseeable circumstances happen. So he's very, very excited, you know. One thing he told me today, because, you know, one funny thing, last week when we went to court on Wednesday, we were planning that he was going to leave before Friday. He would have been out of prison before Friday, and then we would have had a party for my birthday. That was the plan. And Kex's birthday was also previous days. So we had already planned out and say, okay, we're going to have a birthday party because he was going to be out. But that did not happen. So again, he has not given up. You know, when I went there on Saturday on my birthday, he was the one that said, oh, you know, our birthday plans have messed up. But you know what? By next weekend, we'll be able to celebrate. You know, this is the kind of person he is. By next weekend, we will celebrate, because his belief is he is going to come out, because he believes that the results cannot be anything but negative when it comes to him. That's his belief. So he knows. And I want to pray that it comes that way. So your analysis are spot on, and I cannot wait for tomorrow. Right now, Sumo Buti, my eyes are so dry, I don't think I can sleep. I just want tomorrow to come and we get to court by God's grace. And guess what? He was like, you know what? Don't bring the breakfast tomorrow at the court. Bring it at prisons. We eat breakfast. So by the time we go to court, we will be so full that when we were celebrating, we have energy. It was so funny. So this is the plan. The breakfast is not going to the court tomorrow. The breakfast is going to the prisons. So we will all eat and then go to court, because I believe, and he believes, that the results are going to be negative and we want to be so full and have strength and energy to celebrate. So I encourage everybody else, please, to pray. Let's pray, let's pray. I mean, the prayers are not going to change what is on that report right now. But then we pray that whatever the results may be, you know, if it's in our favor, we celebrate it, you know, at the back of our mind that it is God's doing. If it's not in our favor, which I pray that it doesn't happen, I pray it doesn't happen, that God gives us the fortitude, the strength, the will to take it and be able to fight further, because then we will know that the fight has not ended. The journeys will start from there. That's what our belief is, and that's what we pray in.
Thank you, Nene. Brilliant as always. Thank you very much, and I appreciate your kind sentiments and comments. Nene, I'm just going to ask you. I'm putting you on the hot seat right now. I'm going to ask you a direct question. Nene, if the DNA testing results comes out positive, if the DNA testing result comes out positive, Nene Frida Gomez, will you accept the process as credible?
Absolutely not. Absolute outright no.
Tell me why you would not, and tell the Gambian people why you will not accept the credibility of that result if it comes out positive.
Because, again, this is somebody that I know very well. Yes, I was not, I don't sleep with Bob in the same room, right? I am not always everywhere that Bob goes, but there is one thing, I have a relationship that we share, that he has consistently told me the truth and told me things that sometimes I am not proud of him, but he still tells me and looks at me in the eye and say, I'm sorry, my sister, I will not do it again. And when this thing happened, I was with Bob from day one when this thing happened. And I keep on asking him, and he tells me, you know, my sister, I will not do this. You know, my sister, I will not do this. The last straw was when he was finally taken to remand, right? Right the next day, I visited him. Me and him in the room, right? He told me that he is not. He cried himself out and said, why are you doubting me? Why are you doubting me? You know I will not tell you the truth. I will not tell you lie. I did not stop it from there. The next day again, I went with Momodou Sabali. I said to Sabali, man nehuma mbir, te man suma duge dama de duga ak lep. Man duma yoh yohe duma delu gannaaw. Why still now dune dama ko wedi or anything else or gomumako, why dama buga sede. I went with Sabali, and again they brought us to a room. Myself, Bob, and Sabali and God. Even the prison officer, I had to ask that he excuse us. We were in a room, and I told Sabali, I'm asking him again in your presence, because he has told me a million times already that he is not the one. But I just want a witness, so that when I get into this later on, should he tell me a lie or whatever, and I react to whatever he must have told me or whatever, you would have been there to say, you are paying the consequences and everything else. And then again, he got up and just held my feet and cried and cried and cried. It was Sabali that just took him off and put him on the seat. You understand? I said, it's okay, you don't need to cry. We all cried. We left, and I looked at Sabali. I said, I don't have any doubt, an iota of doubt, that this is him. And from that day, I told him, I held him and say, even if the results come to say it's you, I will still be your brother. I will still support you. I will still be in solidarity with you. But one thing I will do, I will openly condemn whatever you have done, because I detest it as a woman, and that is not done. I told him that. Now, coming into the whole prosecution, the whole process, I have been in court. The only time I was not in court is twice. Once I was out of the country. The second time was Fatungone was giving testimony in chambers. Those were the only 2 times that I was not in court with Bob. Even when I'm late, somebody will call me and say, Bob is asking whether you are coming. Or Ellis will text me or call me and say, sis, are you coming? So I ensure that I am in court every day. So everything that has been said in court, I heard it, I know it, nobody can explain to me. Now, the prosecution has brought in witnesses, because coming into the prosecution, they were of this opinion that they had full evidences and everything else to prosecute. But somewhere down the line, you could see the change in their actions and everything that was happening, because you can tell that there were inconsistencies in their witnesses. There were inconsistencies in what the witnesses were saying in court. From all the witnesses that they brought in, there was no consistency. And straight away, even by the time you got to 4 witnesses, you could tell that these people don't have a case. There is no way they can convict with everything that has come so far. Now we went halfway. Oh, by the way, let me say, from the onset, I remember from the police station, Bob was the one that offered to say, let's do a DNA, let's do a DNA, right? Bob was consistently saying that. And at some point in time, you know, the police officers did not charge Bob, because they were saying that DNA should be conducted on both Bob and Pamodu before a charge can be done. Because again, there were evidences to lean more towards the boyfriend.
I don't want you to be prejudicial to the case, because the matter is in court. So I would not want you to talk. You see, if you notice, when I do my analysis, I've never spoken. You know the things that I have in my possession that was given to me by Bob.
Oh, absolutely.
But I have never in my analysis delved into the substantive determinant of the matter. So I don't want us to do anything at this point that would be prejudicial to Bob. So I would just like you to give the analysis based on your understanding of it, but let's not delve into the substantive issue of evidences.
You are the legal mind. For me, I'm just.
That's why I'm guiding. That is why I am guiding you, so that we don't spoil anything at this eventual end. I have so many things. I have recordings. I have so many things. I've never talked about it. I've never talked about it. I've never mentioned it, because I know. And I'm going to say this now. I know I've asked you that question, because I know, as a matter of fact, every single fiber of my being, I know that the test results, if conducted in a just and right manner, and if conducted truthfully and honestly, I know Bob is not the father of that child. I am convinced beyond a shadow of doubt. And this is the first time I am publicly saying this. And I waited to this point because I as a lawyer, I know my responsibilities. And whatever I do, I try to confine myself within the ambit of the law. But I can tell you authoritatively that if the DNA testing is done accordingly, there is absolutely no way under the sun that Bob can be the father of that child. And therefore, it is my belief, my absolute belief, that tomorrow the test results will be negative. So I'll let you carry on.
I believe so too. I believe so too. So again, you know, based on everything that has happened, you remember there was a time I was on Gis Gis. That was the first time I said it. Because I avoid, because of my closeness to Bob and the defense counsel, I avoid making comments and utterances or granting interviews. Because I don't want to do anything that would really jeopardize this case. That's how passionate I am and want this boy to be out. So everything that has been happening, I'm always in court and we discuss it with the defense team. We see the prosecution team driving to court with the witnesses, you know, the people supposedly who put the claim that Bob raped, you know, this little girl. There was this too much over familiarity, you know, with this thing. I know how prosecution works. I am so much inclined with court process and everything else. But it looked like, okay, Ellis is the personal lawyer to Bob, and that the prosecutors are the personal lawyers hired and paid by the complainants. So from then, we started feeling like, okay, this really is not going right. What is happening? But of course, we don't have control over what they do. But then when it came to them bringing in witnesses, and then the witnesses did not really, let's say, to our own seeing from the outside, did not give testimonies that the court, if they had closed without the DNA, there is no way they can get a conviction with those testimonies. Now comes the DNA, which is okay, and which Bob has never had a problem with at any point in time, because he had always been saying, let's do a DNA, because he feels that will really shut in the trial, because that's the only thing that is tying him to this case, to tell you are the one or you're not the one. Finally, the state has requested for the DNA and everything else. What the defense had a problem, or what Bob had a problem was, from the advice of the defense, is the procedures, which was really not transparent, which has so many gray areas that any level-headed person will not subject themselves to such or approve of. And a lot of people, even people who work within the same institution, have issues with the way things were conducted. And by right, I don't think anybody should accept it. And that's why I tell you here that I believe that the results are going to be negative. But, if it should turn otherwise, then I will know that they must have succeeded in their efforts to connive, conspire, and do everything else to get Bob convicted. It cannot be him. That I can lay my life and say it cannot be. They tried. If it comes out negative, then I will know that we beat them in their games, because we cut them in their acts and expose so many things that they must not have been able to succeed in.
You're delving into my next question. My next question to you would be, how will you associate with a DNA test result that goes in your favor to say that Bob Keita is not the father, when you have absolutely stated that you do not in any way believe in such a process? Can you tell me and tell the Gambian people how you would associate to yourself with that result?
Well, absolutely, because without a DNA test, remember, we are saying this is not us. And this is what, because, you know, honesty begins with self. And if the person that is being accused right now tells you that that's not me, so if it's not him, I mean, it's just what he says. It just goes to validate, or just goes to strengthen.
No, you're missing. You're missing the heart of my question. I understand what you're saying, but what I'm asking is that I want to know what strategy, what plans, what do you have in place? What are you armed with to be able, because I know you as a person of character. I want you to tell me straight up how you will associate yourself with a DNA testing result that goes in the favor of your brother, where it is determined that he is not the father of that child. I want you to tell me in plain language, tell the Gambian people how you will. Remember, I gave a scenario where I said I'm waiting to see how Ellis, Camara, the defense, will associate legally with the DNA testing, which they have rubbished and which they have said they will never, ever give legitimacy to. Now, I am asking you, you're not a lawyer, so I'm not asking you the legal basis by which you would associate with this result. What I'm asking you is, how will you factually, how will you morally identify and associate yourself with a result that comes out to say that your brother is negative when you have poked the credibility, delved into the heart of the accuracy of such a report? How will you associate yourself with it?
And that's what I was trying to answer, Mel. That's what I was trying to explain to you. I I have been accused that I've done something. I know I've done it, or I know I've not done it. So now they could have, you know, they're trying to prove that I have done it or I have not done it. Remember, what we have a problem is the process and everything that has happened. Yes, you are right. The defense has associated itself because there has not been transparency from the onset, from the start. And that's the issue that the defense had. Not to say DNA should not be done or DNA should not have been done. Now DNA have been done. I know that, okay, personally, I haven't done it. I'm innocent. And all my expectation is it's going to be negative. And if it's not negative, then I know something has happened because I know it's not. And if that happened, then we will have to now come with our plan B, which of course is not anything that we can discuss online or openly, and to be able to also prove that you guys really succeeded in trying to manipulate everything else. But here on the table, we are showing you that you failed in your manipulation. This is the right thing.
Thank you. Thank you very much. Thank you. Finally, to conclude, I would say that the case of Bob Keita and the state will go on to change the very heart of the criminal justice delivery system of the Gambia. Undoubtedly.
Very well.
I believe absolutely that lessons have been learned in this matter from a spiritual dimension, from a legal dimension, from a factual dimension. As a country, every single person have learned something, a little, in this matter. And I believe that in the final analysis, regardless of what has happened to Bob, regardless of the suffering and persecution that he has gone through, I believe that he will be the catalyst for change when it comes to the dispensation of criminal justice in the Gambia. I believe the judiciary...
Mel, I don't want to cut you short, but remember, we haven't even gone far. Bob's trial is not even ended. And then his own appeal ruling or judgment was used to deny Zainabu Bill. So it has even started to play out in the judiciary system and cases that are unfolding.
That is why I said in one of my shows that a lot has been learned in this case. And I did say that if anyone had said to Zainabu a couple of years ago or 3 years ago that Zainabu, that the precedent, the authority, the legal authority that would be used to put you behind bars, to put you in remand for months on end, would be the authority that was generated from the case of Bob Keita and the state, where you occasioned that case and that precedent and that ruling against Bob Keita. But it comes back 3 years or 2 years down the line. It was on that same basis that your freedom was restricted. That is spiritual. And that for me is deep. That for me is a lesson that every single person that is pursuing relentlessly to bring another person to justice. Remember, when you seek justice, you should seek justice in a very equitable and fair manner. But where you make a decision, a conscious decision, and make a conscious proclamation to destroy the life of another, you should always be careful, because karma is something that does exist. And when you dig a hole for your enemy, don't dig it too deep, so that if circumstances change and you happen to fall into that same hole, it would not be deep. The justice, the legal hole that was dug for Bob Keita was so deep, it was so pronounced that 2 years down the line, it came back, and it was the foundational basis and authority where it was used against Sainabou Mbye, and she was sent to remand. So this is a lesson for every single Gambian. And that is why I say the Bob Keita trial will stand the test of time, in that when the criminal justice delivery system is looked upon, if you look back at its historical involvement, the case of Bob Keita and the state will be the heart of it. And I believe also that Gambians have shown empathy, because 90% of the people that are associating with Bob have never met Bob. 90% of the people that are associating with Bob stand to gain nothing, whether Bob Keita is free or whether Bob Keita is jailed. 90% of the people that have been doing and advocating, 90% of the people that have been using their resources, both financial and manpower, to ensure that Bob has a speedy, effective, fair, and just a good dispensation of justice and trial, are people that have never known Bob or his family. This goes to show you that this matter has touched the hearts and minds of every single person in that country, both in and out of that country. And there is no way that this matter will not be the redefining factor whereby things would be looked at, and those things that are done and are not done in the interest of justice, it will be corrected. And we know that lessons have been learned, and we know that they will be corrected, so that there would never be another Bob Keita. On that note, Nene, I will ask you to say your final words. We started at 9. It's 9 o'clock my time. It's 11, so that means it's 2 hours. So I'll allow you so the next 2.5 minutes, 3 minutes, to give your final words to the Gambian people.
Well, thank you very, very much, Mel. I'm not going to say thank you to you. I'm just going to pray for you. Again, you and Bob have a relationship that is unmatched. So I'm not even going to try to look like you're doing a favor or you're helping somebody. Knowing you would do it all over again for anybody else. So this is who you are. But on behalf of Bob, because I talked to him and he sees, when they have the TV time, he sees everything that is happening in outside. Most of the things, not everything, because they're restricted to the channel that they watch, and it's just for a limited time. So every time I go, he gives me feedback about the things that he watches or things that he sees. And radio also, the analysis that they do on radio, sometimes they say ridiculous things. And I go, he tells me, I'm like, oh, it didn't happen. Don't mind them and here and there. But he is very, very appreciative of everything that is happening outside and the efforts, the prayers, everything that people are doing outside. He appreciates it, and he keeps on saying, thank you and thank you and thank you, and praying to you all. He has not only started praying when he got to mile 2. Bob is a prayerful person. And if you see him, you look at his face, he is very, very serious when it comes to prayers and praying to God and his religious obligations. He keeps on praying and he appreciates it. He is looking forward to coming out and interacting with people. And these days, our conversation is to the foundation he wants to found to be helping prisoners. And guess what? He has already started it. Bob has already paid the petty fines that they pay to prisoners. They fine prisoners and jail you maybe $1,000 for 6 months or $5,000 for 1 year. Bob has already freed 6 people in prison right now who has been fined and they could not pay it and they're in prison. He has already freed 6 people while he is still in jail. And this is something he's passionate. He has experienced the prison. He has encountered prisoners and had stories and experiences. And he pledged that when he comes out, he will ensure that there is change in that place. And I believe that he will do it because he has already started doing it. So I just encourage people to pray for him. This is not me singing his praise. Kuma ham gane man duma sugarcoat te duma gerem ken ko xam ne jarul la gerem neexuma deret. Why look daf ko jar te kuko don la ko xamne la ku jara taxaw la parce que amna taranga amna ngor amna respect amna orma te man lima wax from the onset moy case bi bolé wuñu te case bi duñu tagale di ñaan yàlla nag mu may ñu ngëm may ñu doole may ñu yaakaar may ñu man-man may ñu dal ak muñ ba nga xam ne mboolem lu mun a xappam rek ñu xam ne yàlla la ñu dénk ko wéer ko te ñaan ko mu may ñu mun koo antan suñ yaakaar ak suñ gëm mooy from today mu ne ma ëllëg ma yóbbu breakfast bi ñu ndeewoo ndax ñu mun a celebrate and that's what I believe in when I pray before I go to bed. I pray that we don't get disappointed and we'll eat the breakfast and we make sure that we will leave that condition and not him going back to stay there permanently. And thank you very much, the viewers and everybody else. New Fanan Jama and Ewo Jama. Di ñaax na ku mun a ñëw nga ñëw ku munta ñëw foo mun a nekka nga ñaanal ko nga remember ko nga show support pour ci lim nekk mu génn ci. And thank you very much.
Thank you very much, Nene. You've been phenomenal. You've been amazing. Thank you so much. Thank you so much. Thank you, and thank you again. Like I said before, I believe that tomorrow, right here on this platform, Bob Keita will be out and will join me on this platform tomorrow by this time. This is my belief, and this is what I hold on to. And Nene, if the technician can bring you in, Nene, tomorrow, we're going to be here with Bob. I believe that.
I believe that too.
I believe that. I believe that so deeply. I believe that.
We'll be streaming live. We'll be streaming live in my living room tomorrow.
Tomorrow, I believe that. I believe that. And so what I want to say is let people go out in large numbers to show support. Don't lose faith. Don't lose hope. It is only a dead man. It's only a dead man, a person who breathes no more, whose soul has been taken from him, that will lose hope. Don't lose hope. Always believe. And if you have faith and believe it, trust me, it will happen. So let's all go out. Okay, well, I can't say let us all go because I can't, but I'm there virtually. You know that. I don't miss it for anything. So let's all be there. Let's go and show support. Unprecedented numbers. Again, I would urge, be respectful, do it with decorum, do it with class, and just show support. And let us believe that tomorrow, this trial of Bob Keita and the state will come to its logical and legal end. I thank you all for joining me, and I wish you all a beautiful and pleasant night. Good night, and bye-bye.
Don't be a with Tamala, the fi Amamut Fenen. Sama mam that I'm a one night, Jamareka war. When you're Papolo, don't bena, can do your moon al dara. Reume soon you reula, and yepa and the joke.